Hello everybody, welcome to this video series on www.freedqinfo.com regarding delays and the fraud, deceit, and all sorts of insanity that goes on during the disqualification and appeal process. So in this video, we're going to concentrate on Victor Luna. Again, this is the gentleman who waited 313 days to get his DQ letter. So let's take a look at his DQ letter. And here it is, March 25th, 2009. It's the standard illegal disqualification letter. Note that this is not the NOPD. The NOPD is the Notice of Proposed Disqualification. This is not that document. This is the illegal DQ letter, all right, which the Civil Service Commission has argued is basically illegal in violation of Civil Service Law Section 50.4. So let's move over to the reversal document. Note the date, December 29, 2010. You see that? The disqualification 2009 and then 2010 December. So that's like well over a year just to get the reversal. All right. Now let's look at the most interesting documents of all here, which are the legal arguments submitted by the Civil Service Commission defending the reversal, okay? So as you see here, it says CSL, that's Civil Service Law 50.4, is enforced, okay? Now, quick little fact about Mr. Luna's reversal. It was issued on December 29th, 2010. And go over here, look at this. Due to the expiration of the list under which applicant was a candidate, this matter is moot. So basically, Luna's exam expired 5 days later. So the fact that they made a reversal is basically meaningless. All right. What people are refusing to believe or understand is that a reversal does not mean you're going to get hired. It just means you're going to get the exam is going to get expired, or you're going to be issued the 1 and 3 letter, or they're just going to reissue your disqualification. So it's basically pointless is what I'm arguing over here. Now, let's take a look at the arguments regarding the legality of the disqualification. So as you see here, it says, respondent was not legally disqualified because he was not given a written statement of reasons for his disqualification before his disqualification or afforded an opportunity to make an explanation and submit facts in opposition to his disqualification as required by civil service law. So here they talk about this law. Civil service law dictates that no person shall be disqualified unless they've been given a written statement of reasons and afforded an opportunity to make an explanation and to submit facts in opposition to such disqualification. Again, this is not me arguing this. This is the Civil Service Commission's own documents. They are saying this. So I'm not asking you to listen to me. I'm asking you to look at these documents and see that this is Civil Service Commission. Now, here, this is my favorite part of this document. Basically, Civil Service Commission is arguing that everybody is entitled to the protection of Civil Service Law Section 50.4. So let's read this sentence. Okay. In the case of NYPD candidates, the Commissioner of Citywide Administrative Services has delegated its authority to qualify candidates for the position of police officer to NYPD, and NYPD's processing of potential candidates, as are all candidates for all positions disqualified by the Commissioner of Citywide Administrative Services, is bound by the same dictates of CSL 50.4 and 55 RCNY. That's the rules of the City of New York. So all means every illegal DQ by any agency, okay? Because again, that's what it says here. As are all candidates for all positions disqualified by DCAS. All right, let's go to the next page. All right, civil service law and the rules of the City of New York require the NYPD to provide prospective candidates such as Luna, and everybody else who got an illegal DQ, the proposed disqualification before a final notice of disqualification is issued. Okay, look at it. It says, as required by 50.4. All right. let's look over here. Finally, it did not give him any opportunity to present facts or make an explanation before he was disqualified as required by law. All right, let's continue over here. Again, he is entitled to, by law, required by law, a clear violation of civil service law. All right, let's look at the next set of documents. The NYPD's failure to fully disclose the legal basis of its disqualification before he was finally disqualified, and its failure to ever disclose the psychological standard mentioned in the notice of examination that Luna failed to meet, denied him his legal right to make an explanation and to submit facts in opposition to his disqualification. Therefore, Luna's disqualification must be reversed as illegal. Again, this is what Civil Service Commission is saying. All right? Go to the next page. Without giving him an opportunity to answer this additional basis of a disqualification, which is illegal. I mean, these people, Civil Service Commission, are swearing up and down that the disqualification letter that Luna got is illegal. I mean, it's right here. These documents were submitted to the court. Okay? So if your DQ letter is identical to Victor Luna's, and I'm pretty sure it is, because there's literally tens of thousands of people like you, then you deserve this opportunity to submit facts and arguments against the disqualification. All right, here, Civil Service Commission, in this document, they talk about Civil Service Law, Section 50.4. All right, let's see. For appeals made under Section 50, as Respondent Luna's was, the Civil Service Commission acts as a tribunal of original jurisdiction, and candidates are afforded the absolute right to seek review of their disqualifications. Civil service law requires that no person shall be disqualified pursuant to this subdivision unless he has been given a written statement of reasons, therefore, and afforded an opportunity to make an explanation. All right, this part right here, I love this part. Courts have ruled that the appeal board has the power to reverse the decision below, even if that decision was not arbitrary and was supported by substantial evidence. So Civil Service Commission is basically arguing here that even if NYPD is justified in DQing you, they still have the power to reverse because of these procedural defects. All right, let's go to the next page right here. Let's focus right here. Okay. If sustained, would deprive Luna any opportunity to defend against his disqualification at any time before or after the appeal, and thereby would deprive him of his legally protected right to appeal his disqualification under civil service law. Let's look right here. However, it is undisputed that civil service law requires that respondent be given a written statement of reasons for his disqualification and afforded the opportunity to respond before a disqualification is legally valid. All right? The NYPD did not release the report and records supporting respondent's disqualification until after respondent filed his appeal, and therefore it was impossible for the respondent to make an explanation or submit facts in opposition to a report that had not been released to him or his expert. All right, and I'm going to end this video right here with this line. Only after an applicant has had a full and fair opportunity to present evidence to an unbiased board is the civil service process finally complete. Well, if this is true, and it must be true because this was submitted to the courts by the Civil Service Commission, it means that there's literally tens of thousands of people who have not had that full and fair opportunity to present evidence because all they got was the disqualification letter. They filed whatever paperwork they filed for the appeal, and then the Civil Service Commission just issued an affirmation without having any hearing like they argued they should be giving to people, to submit their, evidence and arguments against that disqualification prior to that disqualification becoming final. All right, thank you for watching. There will be more videos to come regarding this issue.